I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy, otherwise known as ACS. And for those of you who have not been engaged with ACS before, we are a national network of lawyers, law students, law professors, policymakers, and judges who are dedicated to promoting the vitality of the Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. On January 21, 2010, the Supreme Court handed down the 5-4 decision in Citizens United, and in doing so, it struck down significant portions of the bipartisan Campaign Finance Reform Act, also called McCain-Feingold. And in so doing, the court overruled its 1990 decision in Austin versus Michigan Chamber of Commerce. Citizens United has obviously generated considerable attention. President Obama referenced it in his State of the Union address, and both the House and Senate have already held hearings. According to polling that was published last week in the Washington Post, the majority of Americans oppose the Citizens United ruling. But beyond the attention, the polls, the sound bites, there are serious substantive questions. What does the ruling really mean, and what will be its practical effect? Is this a victory for the First Amendment, or is this an opening for corruption of our elections? What litigation will grow out of this case? What might the Supreme Court take up next? And what does the overruling of Austin suggest about the Roberts Court and its respect for precedent, or about the importance of judicial nominations? What are the merits of the relative mechanisms being considered by Congress as a way to deal with the decision and its consequences? These are obviously very difficult and complex questions, but we are very pleased to have an expert panel to discuss these questions and others. Our moderator will introduce the panelists, but I have the pleasure of introducing today's moderator, Professor William P. Marshall, who is a wonderful part of the ACS board. And I could spend quite some time telling you in great detail Bill's many, many accomplishments, but since you have a description in your handouts, I will leave it to that. But I will say a few things. Bill is a visiting professor of law at George Washington University currently, and the William Rand Kennan Jr. Distinguished Professor of Law at the University of North Carolina at Chapel Hill. He has published on a very broad array of constitutional issues and is widely viewed as a premier First Amendment expert. And prior to his academic career, Bill served as Deputy White House Counsel in the Clinton administration, and we are very pleased to have him on our board and have him here today as our moderator. I will now turn it over to Bill.
Thanks so much, and thanks so much for accepting my coming in at the last moment. I know Dahlia really wanted to be here, but she's unfortunately very sick. Well, it's Oscar season, so it's great that we're going to talk about a movie, Hillary the movie, a real blockbuster, had a lot of theatrics. Held over for an extra year before it was released. Apparently there were some technical issues in the release. A special session to release it, mentioned by the President of the United States with a little bit of theatrics in the room as one of the Supreme Court justices mouthed no in reaction to the President's comments. A blockbuster in a legal sense, overruled two precedents, one no more than 7 years old, which, as Carolyn mentioned, upheld at that point the McCain-Feingold legislation, a bipartisan piece of legislation passed by the Congress and signed by President Bush, one of the most deliberated and discussed provisions passed during the Bush administration. The court struck down major parts of that. It placed into doubt, the Citizens United decision places into doubt laws that have their basis over 100 years old, a very broad reading of the First Amendment, one that it's very hard to say that the framers would have thought about, much considered either way. So one thing we do know about this decision is that although it might be in some folks' minds politically conservative, it's not a judicially conservative opinion. In going after precedent and rejecting a decision of Congress, it shows the classic kinds of activisms that judicial conservatives used to criticize. With respect to what it is it a conservative or a liberal opinion? The jury is mixed. People who come at this case from First Amendment view, including Ira Glasser of the ACLU, think the decision was very well founded in First Amendment law. People who come at this issue from the question of campaign regulation think it has potentially disastrous effects for American democracy, and if the First Amendment is based upon the notion of providing us an informed and reasoned electorate, it may have deleterious effects on that as well. The effects on the elections that this decision are likely to cause, I think, we'll get into that discussion in a moment, are unclear at this particular moment. Theoretically, it lets loose the possibility of torrent of money coming into the races. I doubt that it will do that right away. It usually takes some time for these things to develop before corporations or other kind of bodies begin to feel comfortable with doing various things. But it will likely have greater effect, I think, on lower ballot races than higher visibility races because money has a particular importance in creating name recognition, which in turn leads to voter support. In discussing this today, we have an all-star cast. I mean, in every one of these introductions I'm going to make, just add the words, one of the top election lawyers in the country, because it fits to all five of our panelists, absolutely superb and great people. Let me go over them real quickly in the order in which they're going to speak. Monica Yoon directs the Brennan Center's Campaign Finance Reform Project, as well as working on other means of achieving and protecting broader participation in the political process. She has litigated campaign finance and election law issues in state and federal courts throughout the nation and is currently co-lead for the intervener defendants in the challenges to the Arizona and Connecticut public financing systems. Her political commentary has been published in Roll Call, Slate, the LA Times, and she has appeared on MSNBC's Hardball, PBS NewsHour, Democracy Now!, and Bill Moyers. She received her JD from Yale, her master's in philosophy from Oxford University, where she was a Rhodes Scholar, and her BA from Princeton University. James Portnoy is the chief counsel in corporate government affairs at Kraft Foods. He has practiced political law for nearly 2 decades. Since 2007, he has been at Kraft, where he manages the company's political compliance programs and serves as counsel to Kraft Pact. Jim also practiced at Covington and Burling, then served as Democratic General Counsel of the House Administrative Committee and as Democratic Associate Counsel to the Senate Whitewater Committee. Jim has also worked at the Federal Election Commission and at the Justice Department. He has a BA in history from the University of Pennsylvania and a JD from the University of Michigan, where he was elected to the Michigan Law Review and the Order of the Coif. Lawrence Gold is of counsel at Lichtman, Trister, and Ross. He concentrates his practice on helping labor unions, advocacy and charitable organizations, political service providers, candidates, and others engaged in political, legislative, and issue arenas. For the first portion of his career, Mr. Gold practiced labor and employment law on behalf of labor organizations. Separated from his practice at the firm, Mr. Gold serves as Associate General Counsel at the AFL-CIO. In 2003, he was chosen by a coalition of litigants to argue in McConnell versus FEC, challenging on First Amendment grounds the provisions of McCain-Feingold restricting independent public communications by labor unions and nonprofit organizations. So he was vindicated in Citizens United. He received his BA from Amherst College and his Juris Doctorate from Cornell. Joseph Sandler is a member of Sandler, Reif, and Young. Joe concentrates in campaign finance, election law, nonprofit organizations, government ethics, and regulation of lobbying and corporate and tax issues affecting political and advocacy activities. From 1993 until 1998, he served as the in-house general counsel of the Democratic National Committee, and he continued to serve as general counsel of the DNC through his law firm through 2008. He is co-author of Bipartisan Campaign Finance Reform of 2002, Law and Explanation, and has published a variety of articles on campaign finance and election law, and has spoken on panels on campaign finance law and campaign finance reform sponsored by bar associations and advocacy organizations, and guest lectured at numerous law schools, and he is now an adjunct at William & Mary, among others, where he teaches these issues. He graduated from Harvard College summa cum laude in 1975 and from Harvard Law School with honors. And finally, Jan Barron. Mr. Barron was named by Washington Magazine as a top campaign and election lawyer and one of the top 50 lawyers in Washington. He advises clients on all aspects of political law, including federal, state, and local campaign finance laws, government ethics requirements, and lobbying laws. He has argued 4 cases before the United States Supreme Court and has regularly appeared as a television and radio commentator, particularly with Fox News and NPR. During the 2000 Florida recount, he served as a legal analyst for ABC News and abcnews.com. He's the author of the book, The Election Law Primer for Corporations, and he co-chairs the Practicing Law Institute's annual Corporate Political Activities Conference. He received his BA from Ohio Wesleyan University and his JD from Vanderbilt University School of Law. With all the wealth of talent that we have in this room, this is going to be one great panel. Turn it over to Monica.
Thank you so much for that wonderful introduction. Is my mic on? So I'm very pleased to be here today, and I have to say, you know, I've spoken on a number of panels on this case in the last few weeks, and I'm particularly pleased to be on this one because I think of this as a panel of practitioners, a panel of people who have practiced in this area of the law in many cases for decades, and who have thought very deeply about the conflicting interests that exist in this area of law, because this is an area of conflicting interests. Anyone who tells you otherwise is, I think, obscuring some portion of the truth. There is an interest, certainly, in robust debate, in groups being able to express their views on political issues. There is also a recognition that there are real dangers of corruption, corruption both of the quid pro quo variety and the more insidious forms of corruption that happen when voters lose their faith in government, when government becomes increasingly divorced from the interests of the electorate, and lack of accountability is allowed to flourish. And so I know that these views have divided, for example, the membership of ACS. They divided a number of people, and I think that a lot of people find themselves in the spectrum of interest, you know, in this balancing process, somewhere in the middle, more toward one side perhaps, more toward another side. But, you know, most people inhabit the middle and not the extreme. And I think that the public outcry that this opinion has provoked is because of a recognition that in taking its position, the Supreme Court put aside balancing and instead went to a very extreme end of the spectrum. Justice Breyer said as recently as 2002 that in the area of campaign finance reform regulation, there are, you know, First Amendment interests on both sides of the equation. There's the First Amendment interest of the campaigners, those who are trying to speak, whether they be candidates, parties, organizations, political committees. But there are also First Amendment interests and other constitutional interests on the part of the electorate. You know, in informed decision-making, in governmental accountability, and in a deliberative democracy. And so I first became, you know, I have been watching this case with, you know, increasing anxiety for months, of course. And at oral argument, it really struck me how much the debate was centered on one side of the spectrum about corporations and what were the rights of corporations and what was a corporation and how much can you regulate a corporation and is a corporation being silenced. And there was almost no recognition in that discussion that what we're talking about here is an election. What we're talking about here affects the electorate as well as corporations, affects the voters. And I felt like their side of the picture was not painted either in the oral argument or in the majority opinion that followed. And the picture that we get from the opinion is a picture that, you know, we have always said, well, you know, these regulations exist to prevent corruption, and these interests attempt to allow robust participation on on behalf of various groups. And what we hear from the majority is a view of things that really bore no relationship to, I think, the experience of most people with the political system. Senator John McCain characterized the decision afterwards as, or the oral argument as being troubling in its extreme naivete. So we have the court assuming, for one thing, that independent expenditures just cannot lead to corruption. There's no evidence that as long as an expenditure is not coordinated with a party or candidate, that it can produce quid pro quo corruption of any kind. And this is especially disturbing because the court makes this assessment without the benefit of a developed factual record. This case was fast-tracked up to the Supreme Court under the jurisdictional provisions of McCain-Feingold, and it was not remanded for any factual development. So you have the justices assuming that independent expenditures do not lead to corruption, and doing so on the basis of little more than their own gut instinct about how things work. We hear the question at oral argument from Justice Alito, well, in the states that don't have these laws, we don't see a flourishing of corruption, do we? Without a recognition that corruption, when it takes place, doesn't tend to take place out in the open air in the headlines, that you have to sometimes do a little digging. And had they done even the most surface digging, they would have, revealed instances of corruption that are profoundly troubling. One example springs to mind from North Carolina, a farmers' lobby who wanted a particular state legislator to vote for in favor of a farm subsidy. And so they funded and produced a very elaborate series of campaign attack ads against this legislator. Now, these attack ads had nothing to do with the merits of the farm subsidy. They were simply character assassination. And they didn't air these advertisements. They took these advertisements to the legislator's backroom office. They played them for him, and they said, you better vote for our farm bill or else these are going to be aired. This is in the record of a decision called Leak, which is out of North Carolina. And, for the court to be saying that independent expenditures cannot lead to corruption and the government has no, ability to regulate to prevent this kind of corruption is, I think, astonishing. And the second thing that comes out of the court's opinion is this profound skepticism about the goals of reform. We hear from Justice Kennedy that the purpose and effect of McCain-Feingold are to silence entities whose voices the government deems to be suspect. That's a surprising accusation, I think, to make against the people who worked on the passage of this law and the Congresses who continued to pass, generation after generation of reform laws. He also assumes that factually these regulations have, quote, muffled the voices of of the most powerful economic interests in this nation. And once again, I think that vision bears very little relationship to the reality of anyone who has been following the healthcare debates, the bank regulations debate, the climate change debate. The idea that corporations are somehow unable to make their views known to either lawmakers or to the general public is certainly a surprising one. And I'll just end with a note on what the practical effects will be, because I agree that I think that the practical effects will be seen down ticket before they are seen up ticket. I mean, we're not going to see people taking on the most powerful interest in Congress directly. We're not going to see ExxonMobil flooding tens of millions of dollars, or tens of billions of dollars into every race. But what we will see is, I think, a targeting of specific races and a slow normalization of corporate electioneering, a sense that this is what corporations are supposed to be doing, that they are vindicating their First Amendment rights, and that they have a right to go into an election and try to buy as much influence as they can afford. And I think that this is going to have profoundly disastrous consequences for our democracy.
Okay, well, first let me say that I'm here, and what I'll be saying today is my own view and doesn't reflect the views of my company in any respect. It's just my take on how this is all going to work. That's the best I can offer. Election-related issues and campaign finance issues in particular are highly susceptible to what I would describe as sort of a Chicken Little syndrome. Every time something happens in this area of law, somebody on one side or the other talks about how the sky is falling. And I don't really think the sky has fallen. You remember in the time leading up to BICRA and immediately after, there were warnings that it would mean the end of political parties, that it would mean the creation of shadow parties in the form of 527s, that it was unassailable incumbent protection. Well, every one of those dire warnings, while concerning, turned out not to be accurate. It just didn't happen. And I think the passion pretty clearly reflects the high stakes in the electoral process. Because when we're talking about who wins elections, obviously we're talking about how this country is governed and how we all live. And that's something we all take very seriously and care very deeply about. But the reality is really very seldom as far-reaching as the rhetoric. And I have to say that I think that's the likelihood here as well. Citizens United really won't change things much, at least for large public corporations like the one I work for. It may mean more for labor, and I'll be interested to hear Larry's view on that. And there will be some changes. I don't dispute that in the least. But I think fundamentally, we are going to find that the world tomorrow looks very much like it looks today. In no particular order, I thought I'd just give you a few of the factors that in my view, suggest that things won't change very much, at least with respect to corporate behavior under the new legal structure. The first, and I think the most obvious, is that corporations already had a myriad of ways to spend money on politics and on political activity. Any corporation in America, and everyone on this panel who's advised a corporation will tell you that wants to spend money to influence the political process can do so now. The Harry and Louise ads were not independent expenditures. Now, admittedly, there are timing constraints that arise out of BICRA with respect to electioneering communications, and things are a little different. But fundamentally, we're talking about a world where corporations and other large economic interests were already able to play pretty much as they wanted. The additional level of opportunity is fairly small. I think Monica mentioned some of the states that allow corporate independent expenditures or corporate contributions. It's about half the states. I would take a slightly different view of it. I wouldn't say that there's no activity there, but I would say that it's hard to argue, or at least to demonstrate, that the fundamental electoral dynamic is appreciably different in those states than it is in the states that don't allow corporate political activity. You still, on balance, have pretty much the same process. And I think that's what's going to happen at the federal level, too. I also think, coming from in-house and from a slightly different perspective than some of my colleagues here, most people who work in corporate America perceive a trend against corporate activity. And I don't mean one that's imposed necessarily from outside, but most companies that I'm aware of are under more pressure not to engage in politics than they are under pressure to engage in politics. Again, BICRA is a good example. One of the criticisms that we heard was that when soft money was banned, it would lead to the creation of shadow groups that would essentially take the place of the political parties and engage in all sorts of unregulated, undisclosed, and nefarious activity. Well, and that they would do it with corporate money. Well, what actually happened is corporations were thrilled to discover that they didn't have to give the money anymore. They didn't want to. It's one thing to say no when the DNC or the RNC comes calling. It's another thing to say no when a former staffer for an influential member comes and says, hey, I've got this little group that we'd like you to support. It gave corporations a way not to play, and frankly, most of them were happy to take that. I think similarly, the economy today weighs strongly against enhanced corporate political spending. There are few, if any, corporate executives in America today sitting around saying, what are we going to do with all this extra money? Right? I mean, it's just not happening. Now, that does, I think, beg the question of what will happen over the long term and how things will evolve, and I'm not suggesting that that's a permanent trend. But at least for the foreseeable future, I don't see much likelihood of corporations having a bunch of extra cash that they're just looking for a way to spend. There's also sort of a sense of corporations as unified, monolithic entities, and I don't just mean all corporations, but any single corporation. In fact, every company in this country is comprised of diverse and competing constituencies, which have the practical effect of constraining political activity in a large part. You have shareholders and investors, some of whom have one view, some of whom have another view. If you take a public position too strongly in one direction, you anger and alienate the folks who have opposite views. The same is true with respect to employees. You can't get out in front of your employees too far, or you create internal dissent and unhappiness. You have business partners and customers. You can't get out in front of them too much. And not least of all, and many of you belong to these groups, there are a whole bunch of groups out there that are tracking carefully corporate political activity and are aggressively interacting with companies and trying to get them to either ratchet back or change their activity. So there's a host of influences on a company where nobody's in a vacuum just sort of saying, well, okay, I can do this now, I guess I will. There's also, one of the key criticisms that you'll see of American companies in the financial world is that they're unduly conservative and risk averse and that everything is short term. Well, in some respects, that characteristic works against corporate political activity. Independent expenditures, to be effective, are almost always negative, highly personal, vituperative, quite aggressive. It's an extraordinarily unlikely circumstance for a public company to want to put its name or its reputation on the line in that kind of high-risk endeavor. And we can talk about whether there's full disclosure or there isn't. But I think most companies, before engaging in political activity, will start from the premise, or at least most well-advised companies, that it is likely to become public and that you shouldn't engage in any activity that you're not willing to engage in with your name on it. And I can tell you that's the kind of advice I give. I suspect that's the kind of advice that my colleagues here generally give. And I think that's the kind of approach most companies take. Also, independent expenditures, electoral activity, a lot of this discussion I think hinges on an implicit assumption that corporations have an ideological perspective. Most don't. Most corporations are entirely non-ideological and really just take a long-term view of politics, try to be bipartisan, try to get along with both parties, with everyone, the kinds of behaviors that are inconsistent with independent expenditures and negative advertising. And if you look at corporate political action committees, I think you'll see a fairly even split as between the parties, with the trend lines favoring whoever's in power. And that's just how it works. So all of those factors, in my judgment, will significantly constrain political involvement in the kinds of activities that Citizens United now permits. Now, there are exceptions. Let's be clear. Nothing's universal. My own view is that they won't change the political world much, but there are privately held companies that don't face the same public pressures as publicly held companies. Now, I think one could look at that and say, well, if somebody owns a privately held company that's big enough to spend this much money on politics, they probably have enough money personally to spend it if they care that much. So I'm not sure that it really changes the universe of effective actors here, but it is out there. There are certainly companies and trade groups that already have strong political or ideological profiles. And so this opens to them another avenue for activity, and the fact that they've already crossed the threshold of taking risks is an important factor. That's real. That's out there. But again, these folks are already in the game. This is just a new way to play. And there will always be bet the business issues. There will be times that there is legislation out there that, if it's enacted, puts you out of business. And at that point, I think you will see enhanced corporate engagement. And that's clearly right. I think it's more likely to be issue-based than election-based, but nevertheless, it will be out there. And finally, things can change over time. The rules today are exceedingly gray. In a risk-averse environment like corporate America, that tends to dissuade activity. As the rules clarify, as it becomes easier to know what you're allowed to do and what you're not allowed to do, that will, in some modest way, increase the likelihood of involvement. Also, as engagement grows, and I think Monica made this point, I think there will be something of a normalization of conduct, which will also remove some of the stigma, some of the fear. I actually don't think it's going to be a huge factor, but it is a real factor. It exists, at least in some cases. And then the final part, which I haven't heard yet, but which I think many of you will appreciate, is what I would describe as third-party push. You're going to get trade groups, industry groups, and consultants all banging on you to engage in this activity. And they're all doing it not for your benefit, but frankly for their own. Why does a trade group, why does a trade association typically want to increase its political activity? Because it wants to increase its clout. It wants to be a bigger player in town. And one of the ways you do that is by having more money to throw at the political process and to make the case that you have more influence. Now, with consultants, it's even simpler. They want to convince you to hire them to write and place the ads. And they will certainly take the view that it's for their benefit, for your benefit. But I can assure you that it's also for theirs. And I guess the other thing that we have to look for over time is that this could, I guess, be the camel's nose under the tent. Will the court continue the trend and permit additional types of activity? I think we'll have to look at that over time and see where it goes. I'm not convinced that they will, and I'm also not clear what kinds of changes would really radically alter the landscape, but that's certainly something to watch for. So I guess I would just conclude by saying that Citizens United can lead some companies to expand their political activities, but on balance, I don't see that happening now or for the foreseeable future in any material way.
Thanks, and thank you for having me here today. Let me start picking up perhaps from what Jim was saying and talk about the scope of the decision with respect to unions and how they are covered and how it might affect what unions do. There's been, I think, some question or talk about whether the scope of the decision is such that it even applies to unions. Citizens United itself was a nonprofit corporation. The court focused on nonprofits and business corporations in its discussion for the most part. But I think it really cannot be disputed that the rationale of the decision is such that unions are also now not restricted by the federal election laws with respect to independent expenditures or certain electioneering communications, because the rationale of the court, of course, was that Congress cannot disfavor particular speakers. And in this case, it was a nonprofit corporation funded in part by individuals and business corporations, and that obviously applies to any other organization. Whether that is an absolute and will extend as there are future challenges, for example, to corporations that have foreign ownership or purely foreign corporations and the like, I think that will be played out. I don't think those are necessarily foreclosed, but clearly this decision does apply to unions. The rationale also, the court's rationale talked about the marketplace of ideas and the informational value of the First Amendment and the need for anybody in the public to have information from different sources. And obviously unions are a very important source of information and ideas. What might unions do as a result of this? So I think the first thing to ask is, well, what could they, as well as other organizations, do before this decision? Looking at it, and I think Jim alluded to this, there wasn't really a tremendous amount of political activity and advocacy that any organization could do before Citizens United. What Citizens United did was it erased a final line of government prohibition of express advocacy communications by organizations to the general public beyond their members or their shareholders or their executives. And it also eliminated finally what remained of the broadcast ban that the McCain-Feingold law had imposed, where within 30 days of a primary or 60 days of a general election, corporations of any kind and unions could not refer to candidates in a particular manner. For sure, the AFL-CIO and other organizations opposed that provision when it was adopted 8 years ago. We litigated that with many others to the Supreme Court, and we did so because that was really an unprecedented prohibition of a broad scope of speech We thought it was unconstitutionally overbroad. It prevented unions and other organizations from broadcasting messages, even if they really had nothing to do with elections or only might have a peripheral effect on elections, but were timed importantly to advance legitimate legislative and other interests close to elections. And so in this case, we, as the AFL-CIO, in an amicus brief, we did ask the court finally to eliminate the 60-day ban. They did so. We also asked, however, that they not reach Austin. And in reaching Austin and overruling Austin, I think we were maybe, quote, vindicated a little bit more than we had requested in the case. But our point was this, that this was a case that concerned a group that did not use express advocacy. And there was no reason to address that. And the court did not have to go that far, but make no mistake about it, we felt very strongly that it should eliminate the McCain-Feingold broadcast ban. One of the points that we were concerned with about this case was the notion that independent speech by unions in particular could be deemed to be corrupting. This was a notion that Buckley had said was not the case. Buckley, after all, was a decision that upheld the right of unlimited independent expenditures by any source, although it did not focus on particular institutional sources in the case. And the government, in defending Austin, actually in this case in Citizens United, did not support the Austin rationale, really ran away from it, and asked the court to do something it had never done. Which is to hold that independent expenditures, independent speech could be corrupting of candidates and office holders. And we were very concerned about that notion, especially as applied to unions, because not only might it affect electoral speech, but it could affect issue speech. Because a lot of what unions say and other organizations say about office holders has to do with what their official conduct is. And the notion that if office holders view that favorably or unfavorably, it could be prohibited because it would be deemed to be corrupting was a troubling notion, and we weren't sure where that line might fall. Now, the court certainly in this case rejected that view and that analysis. We also pointed out in this case that union independent speech really should not be viewed to be corrupting for another reason, and that is that unions, after all, are democratic organizations, voluntary membership organizations. Members elect officers, members make decisions for the organization, and the associational interests in a democratic organization ought not be subject to the kinds of prohibitions that were afoot there. I think that leads to sort of the question of going forward. I think a very important question will be what is corruption now? What is corruption, the legal concept of corruption that Congress can use in any kind of future legislation? There's been a fair amount of talk about Citizens United. Did it narrow the notion of corruption to just the quid pro quo type bribery corruption, or is corruption a broader concept? I don't think that Citizens United really changed the legal concept of corruption. It relied on Buckley, which said that the notion of corruption is broader than mere bribery. It did say that ingratiation and access, Citizens United did, that ingratiation and access themselves are not corrupting. But I think Buckley said that also. And I think what the court was basically saying there was what gave us pause about the notion of independent expenditures. And that is the notion that something that you do independently, not in a back room showing a prospective ad, but truly independently, if it causes some consequential feeling among a legislator or a candidate, something that you really don't have any control over, that ingratiation is not corrupting. And I don't think the court really has changed that. And that'll be a very important issue, though, because clearly the next cases up in the pipeline are going to be going directly to the contribution restrictions, whether they're constitutional as well. So I do think that the notion that Citizens United changed that has been exaggerated, but we'll see. I mean, the court, obviously being the Supreme Court, could say that that's in fact what it did mean. Last point I just want to make at the outset is that as it did really in McConnell and is done now, I think the court has erased any legal distinction between electoral speech and issue speech. And I think this is a really important point. It was implicit in the McConnell case, but if you read the Citizens United decision, it doesn't talk about issue speech here and electoral speech there. It uses fairly often the phrase political speech. And basically what it means is advocacy about public issues, what the Supreme Court used to call, I think, speech about matters of public concern. And in the disclosure portion of this decision, remember this was 5-4 about overruling Austin and McConnell and the like, but 8 justices endorsed the current legal regime requiring disclosure of independent expenditures and disclosure of electioneering communications, no matter what the source was. And in that portion of the decision where 8 justices agreed on the language of the decision, they pointed out that the court has upheld registration and disclosure requirements on lobbyists, even though Congress has no power to ban lobbying itself. I think that's one of the most important overlooked statements in this decision. That all the justices almost, and I'm sure Justice Thomas would agree, the 9th justice, that Congress has no power to ban lobbying itself. Now, if you put in that line independent expenditures, electioneering communications, well, there are 4 justices that don't agree with that. But the notion here is that lobbying, pure issue speech, advocacy, engagement with the legislature, no power to ban. And I think that's a very important, powerful statement looking forward, because a lot of the commentary, I think, about this case and about how corporations and unions and others engage in political activity, often they're talking about lobbying. They're not even talking about politics. So we'll see where that goes and whether the 4 justices who are the main dissenters in this case, how they carry that forward.
Thanks, Larry. Thanks very much for having me. I wanted to talk briefly about the implications of the decision for nonprofit organizations and the party committees on the Democratic and progressive side. And I think Jan will touch on some of this on the Republican side. Of course, there's a substantial new progressive infrastructure since it's grown up since 2000. ACS is a critically valuable and important part of that. And it is true now, under the campaign finance laws, as changed by Citizens United, that nonprofit organizations using union and corporate funds, unlimited union and corporate funds, can run or pay for communications that basically say anything up to and including vote for or against a candidate, and do so through any medium. But there are significant constraints, some of which have been overlooked in a simplistic view of the impact of the case. Most of our groups that are active in the advocacy and political arena on the progressive/democratic side, if you will, operate in the form of nonprofit organizations that are social welfare organizations under the tax code, 501c4 organizations that can engage in unlimited direct and grassroots advocacy on issues and legislation, or in the form of political organizations, so-called 527s, which are not registered as political committees with the Federal Election Commission or under the state laws. A 501c4 organization can spend money on political communications now under this decision, union and corporate funds advocating for or against candidates. But under the tax laws, that can't be its primary purpose. So you're not going to see, it's not possible to come, this August, this September, October, so I want to form a new C4 organization. What we want to do with it is just, spend money to pound the hell out of conservative or Republican candidates. That's a constraint under the tax law. Now, you can form a political organization that claims exemption under the tax law as a so-called 527, unlimited activity that the IRS considers partisan. And under this decision, such a group can spend unlimited corporate and union funds, again, to certainly issue advocacy, advertising, including broadcast advertising, that it could not before under the McCain-Feingold law, under those provisions that the Supreme Court overturned in this case. But a group, political organization, 527, that wants to take full advantage of this decision and advocate for or against candidates or cross the line into what we call express advocacy, risks being treated as a federal political committee. And this is another sort of lesser understood and significant aspect of this, and sort of the next frontier of the law here. Because if you're a federal political committee, if you cross the threshold into being the kind of organization that the Federal Election Commission, the federal campaign finance laws are allowed to regulate, the limits to that committee, ban on corporate contributions, ban on union contributions, limits on what an individual can give, all of those were upheld by the court. None of those were touched by this decision. And the question of when a group becomes a political committee is one that's never been clearly answered. Suppose you spend $1,000 on communications advocating for against a candidate, and the FEC finds, Federal Election Commission finds that your major purpose is federal campaign activity, a very vague test that has never been clearly defined. If you are a federal PAC, federal political committee, both before and after this decision, of course, you could say anything at any time, using limited contributions, say anything at any time independent of a candidate in any medium. The question is, if you are a federal political committee and all you cross in over this threshold and all you do is independent communications for or against candidates, do the limits on contributions to such an organization, are those constitutional? That's the next big case that's coming up. No guarantee that the Supreme Court will take it, but the Speech Now case that was just recently argued before the U.S. Court of Appeals for the D.C. Circuit addresses precisely that issue. And that's, again, an unknown. And in the meantime, you can see that the uncertainties actually would act in a sense as a constraint on what nonprofit organizations and 527s can do to some extent. It's not quite as wide open and wild, wild west as you might think on first examining the decision. With respect to the party committees, certainly I think with respect to the party committees, there's a legitimate, understandable, logical concern that all things being equal, this decision that opens a door for unlimited spending by other players in the political process will further reduce and marginalize the role of political parties. On the other hand, as Jim Portnoy pointed out, we thought that was true of McCain-Feingold, and it didn't necessarily turn out that way. And there are some countervailing factors there that make the role of parties still quite significant. First of all, remember that under this Citizens United decision, everything you're allowed to do, everything an entity is allowed to do, has to be independent of a candidate or party committee. And that's precisely why the court thought it was of reduced value. You can't communicate or coordinate with the candidate that's benefiting from this expenditure. Party committees can coordinate with their candidates. They can make independent expenditures, but they can coordinate with their candidates, and particularly with respect to activity on the ground, field activity, engaging voters at the door on the streets, mail, phones. There are things that they can do in coordination with their candidates, expending a lot of resources that no other entity can do, and we saw this certainly in the Democratic Party and the Obama for America operation in 2008. The other thing to keep in mind is that parties have a much larger permanent infrastructure than other players in the process. Through the state party structures, through entities like projects like the 50 State Project under Chairman Dean and Organizing for America, now under the DNC under the Obama administration. And again, that's an advantage that other players in the process won't have, notwithstanding the advantages they gain from this decision. So it's really hard to predict, here as in other cases, as Jim correctly pointed out, the implications of this with any certainty for nonprofit organizations and party committees, and some of those implications indeed depend on these developments that are still unfolding. John?
Well, thanks to ACS, I'm always glad to show up on these panels as sort of the pet Republican. And I've enjoyed my many occasions where I've been extended an invitation, which I gladly accept. I would like to make a couple of preliminary observations regarding this case and then get to some points relating to what it might or might not mean for political parties and even business organizations. As many of you know, I did a piece for the New York Times shortly after this case was handed down, commenting on two things. One was the relatively limited result of the decision in Citizens United, limited in the context of what is it that was now permitted that had previously been prohibited of corporations and unions. And the answer to that is, well, unions and corporations now may say vote for a candidate or vote against a candidate. They no longer have to finance advertising that says, call up candidate Smith and tell them to stop raising our taxes, which is something that was permitted and actually constitutionally protected. The other observation I made in the article was that the reaction to the decision was, in my opinion, highly disproportionate to actually what the result was. And after thinking about this some more over the last few weeks, it seems to me that there are two reasons why the reaction has been so strong. One is that campaign finance cases seem to me to sort of touch the third rail of American politics and the divisions that many people have regarding basic democratic principles. Does the Constitution advance equality, or does it protect individual freedoms? Are we supposed to analyze these First Amendment issues by, as Monica suggested, balancing the interests, or do we apply strict scrutiny when the government tries to limit a fundamental freedom? Do we, meaning the justices, when they get these types of cases, do they defer to the government when it regulates political activity, or are they supposed to be suspicious and restrain the government from regulating campaign activity? It's essentially, the debates that justices like Nino Scalia and Stephen Breyer have and their books. So I think that's one reason for the reaction, because people who think, well, campaign finance ought to level the playing field and equalize resources and prevent some folks from speaking and enhancing perhaps the relative role of others, that's what they ought to be doing, as opposed to equalizing by letting everybody engage in independent expenditures. I think the other reason the reaction has been so strong is that the Citizens United case essentially returns Supreme Court First Amendment campaign finance jurisprudence to Buckley versus Vallejo. We had 35 years where there were attempts to basically make Buckley a little more elastic. There were 30 years of decisions involving independent spending. Buckley dealt with independent spending by individuals. The original Watergate reform had a $1,000 limit on what any individual could spend on their own regarding a campaign. And subsequently, we had cases involving the same principle pertaining to limits on political committees, on political parties, even not-for-profit corporations such as Massachusetts Citizens for Life. And yet there was this one outlier in 1990, Austin versus Michigan Chamber of Commerce, which at the time, I think a lot of people were surprised in terms of how it could be reconciled with the First Amendment jurisprudence in these other independent spending cases. The result, therefore, if I am correct that we're going back to first principles, is that regulating campaign finance is now going to hit a brick wall, back to where it was in Buckley. You have to discard the language from the McConnell decision that suggested that Congress would be deferred to, that they have great latitude to regulate, even to prevent so-called circumvention of different things. I think this decision says no, when it comes to independent spending and other basic principles, what we said in Buckley, we meant, and that's the scope of government regulation. Now, why did the court make this conclusion with respect to corporate and union independent spending? And I think that both Larry and Monica touched on it, which is there has to be some showing of corruption. The court doesn't didn't say, either in Buckley or in any of others cases, that it's impossible for the government to come in and say, well, independent spending under certain circumstances may corrupt. If the government can make such a demonstration, presumably the court would take that into account and say, well, you have met your burden in demonstrating this threat of corruption, and therefore we would have to rethink all of our cases involving independent spending. But the government did not do that in Citizens United. I filed an amicus brief on behalf of the United States Chamber of Commerce, which was devoted to this issue of what is the burden that the government has to bear in sustaining any restriction on First Amendment freedoms and freedom of speech. The burden is they have to demonstrate that there is a threat of corruption. We also noted in our brief that 26 states and the District of Columbia have no prohibition on independent spending by corporations. There are more states that don't have any restriction on union spending. Of course, all of them now have to repeal their laws because they violate the First Amendment. Surely, with that many states allowing unlimited corporate and union spending, there must be some evidence that the government could present to the court in any of its two opportunities, a full briefing and oral argument, including the example that apparently exists in North Carolina, and say, well, Your Honors, here's an example of independent spending being a threat to corruption. But the government did not do so and was unable to for whatever reason. In the future, maybe some demonstration of that sort can be achieved. If it can, then I think the court would revisit the proposition, and then they would revisit it not just in the context of corporations and unions, but maybe billionaires ought to be restricted on how much they spend, or millionaires, or whatever the denomination is at that time. It could be trillionaires by then with our impending inflation. But they would have to apply this equally to all independent spending. Let me turn to the political parties and comment a little bit on businesses. The political parties are basically left where they were before this decision. They were defunded in McCain-Feingold of their soft money. That was in $2,000, $250 million each. Republican and Democratic national committees had received a total of $500 million in soft money. They are unable to accept such money since 2003. That prohibition remains intact. It means that they will not be able to increase their resources except by collecting money from individuals and political action committees in limited amounts. Of course, the Democratic National Committee doesn't allow contributions from PACs anymore. Is that correct? Or lobbyists? So they will rely on untainted small dollar contributors. And in relative terms, I think it is in some ways safe to say that the national party committees have had a relative reduced role in the campaign finance scheme. I think this was dramatically underscored when President Obama raised $750 million. I mean, that was his money. That wasn't the party's money. It was underscored in 2004 with the spending by the 527 organizations, and then we've had other types of spending. In fact, just to put everything in perspective, 2 days before this decision, there was a special election in Massachusetts for United States Senator. There was a little publicity about that. And in the course of that special election, over $4 million in advertising was spent by corporations and unions under the old rules, which sort of underscores 2 points. Number one, there was a lot of spending, and number two, that the scope of this decision is not in the nature of unleashing corporate and union spending. It's just that they are no longer subject to content restrictions, such as saying the words vote for or vote against, and they are no longer subject to timing restrictions in terms of when they can send certain messages through television, radio, cable, and satellite. So I think the parties are going to be they're going to be unaffected as a legal matter. Their relative role, unless the rules are changed to allow parties to raise more money in different ways or to spend more money for their candidates, their role is going to, relatively speaking, probably continue to be either the same or slightly reduced. Of course, that soft money that was eliminated, by the way, with McCain-Feingold, it didn't disappear. You know, it's pretty much going to the Democratic Governors Association and the Republican Governors Association. If you look at their reports, that's where all the soft money has wound up. In terms, finally, of the business corporate community, I agree with the comments that Jim made. It's going to affect different organizations differently. There are only Fortune 500 companies, but there are 3 million corporations that file tax returns with the IRS. And obviously, the great vast majority of business corporations are wholly owned or closely held. So these are going to be vehicles by which stockholders, who are the owners, tend to be family owners or a small group of owners, to the extent that they may have been politically inclined to fund independent spending in the past with their own personal money, well, they now will have the latitude, if they so choose, to simply use their family corporation to make that money. The publicly held companies are going to be restrained for all the reasons that Jim outlined. And then we will have the public or the not-for-profit entities, of which there are a great variety. Groups like the National Rifle Association, the Sierra Club, which have already sponsored advertising over the years, presumably will continue to do so, and their only decision is, well, can we get more money to do more of this advertising, and now we can say vote for or vote against. That's what this decision makes. I don't know what's going to happen. My own impression is that everyone is sorting through this case and its practical implications right now. They're also waiting for the Federal Election Commission to undertake its rulemaking to confirm the scope of how it changes all of the FEC rules. And of course, some are waiting to see whether Congress is going to pass something. But as I've told others before, I will make one bold prediction, which is that there will be more money spent in the next election than was spent in the last election.
Well, I want to thank all the panelists for their formal remarks. I did not detect complete unanimity among the panelists, so I thought I'd open up a quick internal discussion among the panelists as to flesh out each other's comments before we open it to questions from the press. So, Monica, can I start with you?
Sure. I think that what a lot of the panelists seem to be agreeing on, you know, as lawyers who have practiced in this field, is prior to this decision, if a corporation or other group wanted to speak, then it could speak. It could speak about political issues. It could speak about candidates. It might have to do so through a PAC. It might have to do so through other means, but it could speak. There was no, you know, corporations were not being silenced from putting their voices into the public debate. And I think that for the court to constitutionalize this issue, to say, okay, it's no longer a question of us trying to work out with Congress what is the optimal way to balance these competing interests, but for the court to say, no, these options are completely off the table, is what struck me as being so extreme about this decision. Jan referred to the dearth of evidence before the court regarding corruption. I agree, there was a dearth of evidence. And I think that the government and certainly the congressional sponsors of BICRA's brief pointed out to the court that, look, if you were going to do this, if you're going to make assumptions about the way independent expenditures function in the political system, then at least remand to the district court for findings about that. At least look at some of the evidence that we all know is out there and that you are choosing to turn a blind eye to. And indeed, one of the things that we asked Congress to do in our testimony a couple weeks ago was to convene hearings as to what threat of corruption is there from these kinds of independent expenditures. I'll just do one quick example that'll pull me into my conclusion here, because so Intuit Corporation, publicly traded corporation, perfectly legitimate, not usually one who you would think of as particularly partisan, but they injected $1 million through a trade association into the California comptroller's race. And why did they do this? Because the California comptroller was going to put out a free online tax filing system so that California citizens could file their taxes for free online. This was going to cut into the sales of TurboTax, an Intuit product in California. And so they launched a $1 million attack ad blitz against that comptroller. They did so through a trade association so that their involvement was not known until after the election. And this is kind of why disclosure is necessary, but disclosure is not enough. Disclosure doesn't remedy your wrong if you have a last-minute attack ad blitz on the eve of an election. By the time you find out who is behind it, it's already too late. The election is over. And I do agree. I'm not reflexively anti-corporate. I mean, I was a corporate lawyer for 10 years before joining the Brennan Center. I represent a number of corporations, as do many of my friends. I agree. I do not think that most mainstream corporations want to get involved in this stuff. What does tend to happen, though, is what we saw happen in the soft money days, which is a race to the bottom. Like, one competitor joins in the fray, and then, and then you get this sort of, he's doing it. Maybe I have to do it now. Maybe, that guy just just funded $1 million attack ad campaign. Maybe I have to get involved. Maybe this is something we should be doing to maximize our bottom line. I think that race to the bottom is something that very mainstream corporate lawyers have been calling me and saying that their clients are currently concerned about. And, it's something that, recalling how cheap congressional elections are in the corporate scale of things, recalling that a Senate race can cost as little as $5 million. A House race can cost as little as $1.3 million. We're just not talking about massive amounts of corporate expenditures here.
Any other panelists would like to comment before we open it up to general questions?
Yes.
Just curious if the panel can talk at all about judicial elections. I know Justice O'Connor has been outspoken about that, and just wondered what the panel thought.
I mean, I can talk a little bit about it.
Might repeat the question for the audience.
Sure. The question is about judicial elections, and Justice Kennedy does draw, in his opinion, what I think of as a somewhat unconvincing distinction against the way independent expenditures work in a judicial election. This is from the Caperton case, in which Justice Kennedy wrote the case last year. That was a case in which the CEO of a coal mining corporation was faced with a $50 million jury verdict against him, and he knew that a state Supreme Court justice who was up for re-election was likely to rule against him, and so he spent a $3 million attack ad blitz to basically take out that Supreme Court justice, and the new justice who had won his seat certainly partially because of this attack advertisement, although I don't think that there was any particular evidence of coordination, did not recuse himself from the case and in fact voted in favor of the coal mining corporation. And the case went up to the Supreme Court as a due process challenge brought by the litigants, saying, look, you've violated my right to have an unbiased judge here. And so Justice Kennedy does say that independent expenditures are concerning in that instance because litigants have a right to an unbiased judge, which made me wonder, when he's distinguishing that, well, does he think that the electorate has no right to accountable officials? But there has just been the same people who launched Citizens United just launched a newly fledged attack on the Wisconsin judicial public financing system, I think last month, which we are assisting in defending.
Are there any members of the press, yes, that have a particular question?
I didn't hear a lot of discussion of potential congressional reaction to this and what you think Congress will do and how that might affect the scenarios that you're outlining about what the reactions are going to be.
And specifically, if the panelists could also reference the requirement that some are proposing that shareholders need to vote to allow corporations to engage in this, which is one of the forms being mentioned.
Well, I in a former life, I was the elections counsel on the House Administration Committee for the Democrats. So I will tell you that I view with great skepticism the prospects of campaign finance reform legislation getting through Congress. I mean, they were lucky to get a jobs bill done. I think realistically, it's unlikely that there will be meaningful legislation in this area enacted. But if you're asking me about the substance of the proposal for shareholder approval, I will tell you that I personally view that as an effort to preclude corporate political activity, not as an effort to protect shareholders in any meaningful way. And so I view it with some skepticism. I would argue that there are actions that corporations take that are far more significant from the perspective of shareholders than political activity that don't require shareholder approval. And so if you're really looking at sort of shareholder democracy, there are other places that I think one could look more profitably.
Yeah, I wouldn't handicap quite so severely as Jim does the prospect of some kind of legislation, especially in the disclosure area where the court obviously has strongly affirmed Congress's ability to generate disclosures, and I think that there's more that could be fruitfully done that the court would, except for Justice Thomas, would endorse, including a more focused disclosure on transfers of money, for example, from a corporation to a trade association. In that Intuit example, it has to be done carefully. It ought to be done, I think, precisely in order to achieve a meaningful disclosure goal. As far as the these proposals about approvals and the like, I think there are clearly there are some things that Congress could do on the shareholder approval front that might be beneficial. But when that principle is applied to other organizations, as inevitably the debate will shift, then I think it becomes way more problematic. And just taking unions as an example, there are statutory requirements for members of unions to vote on particular matters that have to do with the structure of the organization, its officers, raising dues, that sort of thing. But there has been no substantive, and I think should be no substantive legislation that requires members of unions or any other group. There are a lot of membership organizations out there. C4s, the Sierra Club, and the NRA were mentioned. And for Congress to hobble these organizations' regular democratic operating structures by dictating that on particular matters there has to be a particular advance approval, I think is really very undemocratic. And I know that the AFL and other unions I've spoken with would oppose that sort of a venture.
Joe, were you?
Just quickly, I agree with Larry. I would not count out the prospect of federal legislation, particularly along the lines of the leadership proposal that's been put out that does not actually go to shareholder approval or touch the area of corporate governance, but emphasizes limits on independent expenditures by foreign-controlled entities and disclosure. If there's one thing that unites Republican, Democrat, liberal, conservative members of Congress, it's that when they see issue ads being run against them, harshly criticizing them, they want to know who's behind them. They want to stop it if possible. That's how we got into this thing to begin with. Mm-hmm. The election, these provisions, the 30, 60-day provisions of McCain-Feingold were not proposed, in fact, by the reform groups, but by a bipartisan group of members of Congress that hated these ads being run against them. So I would not count out the prospect of legislation moving. That being said, the shareholder governance type of legislation you're seeing really coming out of the states, and that I think will be the first test. There's a number of bills moving through state legislatures. Odds are one of them gets through and does get tested in the courts, and that'll be very interesting.
Well, are they constitutional? I mean, one of the interesting thing about Austin is that it talked about, and this was Justice Rehnquist, actually, when he was Justice, not Chief Justice Rehnquist, was skeptical about the very notion of corporate speech, because it's an artificial entity created by the state and sort of equate the corporation with the individual on the soapbox was somewhat artificial. The way to go at that, I suppose, is to go after the rules of corporate governance and corporate structure. I mean, my question to you is, as First Amendment lawyers, is would that be constitutional to try to use rules of corporate governance to try to limit this kind of activity?
I don't know. It's an issue that I intend to study a little more, particularly in the context of corporate law. Obviously, the principle of requiring shareholder approval for certain things in public corporations has ramifications well beyond campaign finance. I can observe, however, that The proposals that are coming out, according to their sponsors, have one specific intent, and that is to deter corporations from exercising the First Amendment. Those aren't my words; they're their words. You know, if you look at the public statements from Senator Schumer or Congressman Van Hollen, they specifically say all of our proposals in our legislation, which they have not yet dropped in the hopper, will have a deterrent effect, and that's good because it will reduce the amount of spending by corporations. I also would suggest that any of these proposals presumably would have equal applicability to unions, would it not, Larry? I mean, you'd have to get a vote of all your union members to spend money in that fashion, or you'd have to make certain disclosures. Of course, comparing unions and corporations oftentimes are apples and oranges in terms of the effect that a particular law may have, but every corporate proposal I've seen so far does not seem to include unions in it as well.
Well, as I said, I think the situations are different. Unions differ from business corporations, and I think that proposals that override ordinary democratic processes within unions and other membership groups, I think would have serious constitutional concerns.
Any other questions from members of the press? Okay, yes.
Hi, Federica Scouten with USA Today. Quick question on the proposals having to do with foreign ownership and the 20% threshold. What's the legal basis for a 20% threshold?
Did everybody hear the question?
Oh, sorry.
The question was proposals have a 20% threshold on foreign ownership, and what would be the legality of that kind of restriction?
Well, there's a overriding issue, and it came up in oral arguments on the second round at Citizens United, which I think counsel was asked by someone, how will this affect foreign corporations? Do foreign corporations have First Amendment rights? And Ted Olson responded, well, yes, they do. I mean, and I think that's an accurate statement. The question isn't whether they have a First Amendment right. The question is, does government have a justification for treating them differently than domestic corporations? So there will be that constitutional issue, and surely the government by that time will have lots of evidence in carrying out its burden to restrict foreign corporations to present to the court. But in the meantime, regulating foreign corporations on the basis of 20% foreign ownership, I'd like to see, some of the statistics on what those implications are. How many companies that we would generally consider to be U.S. companies might have more than 20% ownership abroad. Of course, they'd have to determine, how much of the stock is in street name versus, actual name of the stockholder. What about corporations that earn more than 20% of their revenues from abroad? I'm thinking here General Motors. I mean, apparently their only profitable sector is in China. Does this mean General Motors is now going to be a foreign corporation, even though they're headquartered in Detroit? We went through this debate 10 years ago, or even just 7 years ago, when McCain-Feingold passed, because there were issues of, does McCain-Feingold change the law on foreign nationals, as some people suggested? And all of a sudden, Daimler Chrysler comes to Washington and said, we're owned by Daimler AG, but we've got 300,000 employees here in the United States, and we've got all these manufacturing facilities. We don't think we're foreign in the meaning that the law suggests, and to the extent that we are, then we still want to preserve the rights to engage in lawful political activity in the same fashion as other companies here in the U.S. That represent American employees. So this is not going to be an easy issue, and it will raise lots of both practical and constitutional issues.
Other members of the press with questions? Yes, sir.
Peter Overby from NPR. Peter Overby from NPR. What about the stand by your ad provision? Are we really going to see CEOs appearing on TV with their ads?
Well, I can just say I don't think Tom Donahue has any hesitance to show up in his ad and say, you know, I'm the president of the U.S. Chamber of Commerce and this is our ad.
I mean, I think a problem is how, you know, the trade associations are going to be a big issue there. I mean, what do you do with ads that are funded through trade associations? What do you do with other associations of corporations that decide to run ads? What do you do about misleadingly named, you know, nonprofit conduits? You know, and I think we have yet to see the, you know, the way they actually propose to work these out. But, you know, trying to capture all of that in disclosure is very difficult, and really I don't think can be seen as a complete solution to the problem.
Questions from other members of the press? What? Well, yeah, but I want to do the press for any questions from members of the press? Okay, general public. Yes.
I don't think there was any inconsistency in the court's ruling, if you understand the philosophy they are operating under. The philosophy of this court, they are legal Darwinists. They're incorporating the theory of legal Darwinism and how they approach cases before them. They go back to the 20th century legal Darwinists that converted the 14th Amendment, defining corporations as persons, to set a Magna Carta for business to be not interfered with or regulated by the inferior masses. It is to incorporate the social statics of Herbert Spencer, who incorporated the theory of Darwinism applying in our legal system. And that is what is happening. If you want to be consistent, I have predicted what would happen. I am consistent, can predict what they're going to do if you apply the correct model that they're operating under. It has nothing to do with the First Amendment. What it says is that the corporate person, as the highest development of the person in our political system, the corporate person is the survival of the fittest and should not be regulated or interfered in any manner of speech or operation by the inferior masses. That they are operating from a supremacist legal dominance ideology. And if you can't admit that, if you can't address that, then you will continually be confused by the supposedly inconsistent legal decisions that they make. Now, I would like you to explain, anyone on the panel answer, why is this not consistent with the same kind of legal decisions that were made during the 20th century in order to protect the robber barons corporations against the regulations of the masses through their conduits political representatives? Why is this not a neo-legal Darwinism?
Well, if I can quickly just respond to that. I mean, there are some who've argued that some of these decisions, particularly with respect to corporate speech and commercial speech, are one that tend to favor entrenched interests. But I think the First Amendment side of this, for those who are advocates of the First Amendment, there is certainly central to the First Amendment is the notion of talking on political issues. And so that the issue, I think, is far more complex. I think it was stated earlier quite well by Jan in saying that this decision reflects part of the tension in the Constitution between those who support freedom and those who support equality, and you can have legitimate views on both sides of this. It's why it makes this a very difficult issue, because I don't think even the most laissez-faire person doesn't think there is some problem with the way that campaigns are funded in the United States. The question is, how do you deal with that issue consistent with the First Amendment? You had a question.
I think that didn't answer my question. Let me just comment that I think that this ambivalence is even reflected in the ways some justices vote. I'd like to remind folks that one of the 3 dissenters in the Austin case was Justice O'Connor. And one of the 6 in the majority, as you suggested, was then Justice Rehnquist. But they flipped sides in the McConnell case, and then Chief Justice Rehnquist said, well, I was wrong in Austin. I think that free speech, even by corporations, is really at the core of the First Amendment. And obviously Justice O'Connor must have said to herself, I was wrong in Austin, we ought to regulate all this. So there's not a straight line on this, even on the court itself.
If you look at this on just a purely pragmatic level, we've seen more money spent on elections than ever, and it continues to increase. If you take away certain limitations, such as the PAC limitations on corporations and spending money, aren't we going to generate a huge amount of economic waste in the sense that we'll become less competitive towards other countries because of the amount we'll be spending on elections, money that ends up influencing politics but leaves just, the general market?
Well, I think certain sectors of the economy, such as political consultants in the broadcast media, will be doing very well.
Not to mention lawyers.
It is true that the amount of money spent on elections is not that sizable compared to other kinds of corporate expenditures, but there is a certain disutility in this too. Yes, sir.
Hi, Arn Pearson from Common Cause. So there's obviously a fair amount of disagreement amongst all of you about the constitutionality of regulatory responses to the decision, but I would be interested in your response, your thinking on the constitutionality of a voluntary public funding approach, which looks at, if you look at the secondary effects that we're likely to see of escalating arms race for fundraising, or the appearance of influence or intimidation by expenditures. Another approach is to provide candidates a floor of spending that frees them up from, depending on special interests. And without asking you for whether you favor that policy, I would be interested if people would agree that that approach is constitutional.
I mean, the case that dealt with it directly, of course, the Supreme Court case is Buckley, which upheld the original public financing mechanism for presidential elections. I don't see anything in Citizens United or any cases since that cast doubt on the constitutionality of a voluntary public funding system. There was a case decided by the Supreme Court a year ago, the Davis case, which addressed the so-called Millionaires Amendment, which may impose some constraints on how the triggers for public funds, namely that independent expenditures by others may not be able to trigger increased amounts of public funding for particular candidates who are the targets or the campaign opponents of a beneficiary of independent expenditures. But I think I'd be very surprised if the court, and I would be dismayed if the court were to hold that and extending the public financing system to some manner to, say, congressional elections or state elections and the like was unconstitutional.
I agree with that. I think public financing is the solution to a lot of what we're talking about. I think it's constitutional. The problem is there's a culture in this country that rejects it, and it makes it so difficult to, remotely conceive of getting it through the Congress. And then it's a whole discussion in itself. But in other countries, in Canada, the parties get $2 a voter from the public treasury. To spend. Nobody thinks anything of it. Here, welfare for politicians, unthinkable. I have to say the reform community has a tough road to hoe here to change the political culture around the public financing issue, but therein lies a solution that's clearly, constitutional as well as most promising.
I think there are
effects.
more practical considerations. I mean, a lot of things can be constitutional but may not work, and of course we saw that with prohibition of alcohol is the most dramatic example. And when it comes to public financing, obviously, we had presidential public financing that was approved by the Buckley Court, but it doesn't work. And so people have to ask, why is that? Why is it that both Senators McCain and Obama, did not participate in that system? I know it comes as a surprise. I have supported public financing in limited circumstances, primarily with respect to judicial races. I was on a ABA commission that came up with this type of recommendation. I do not support spending limits, but why do I support public financing for judges? The reason is that They have to stand for election, and where in the world are they going to get their money for their campaigns? They don't have any fundraising base other than lawyers and litigants, which is not a really healthy proposition. And 38 states insist on electing their judges. So the public say, we want to have elections for our judges. So you got to give some money to these poor people to run their campaigns as a base. But there are other bells and whistles that are often proposed, which I think make it impractical and sometimes potentially unconstitutional, like jiggering how much money they get based on the independent speech of somebody else. Well, I think the Davis case casts a constitutional doubt about that type of an approach.
We have time for one more question.
Miriam Galston from George Washington University Law School. This is addressed to people who say that the Catholics CU won't really affect corporate spending all that much, at least in the short term. And you talk about attack ads or ads generally. And my question has to go with registration and other get-out-the-vote activities. Do you think that the change in the law will affect that? And the reason I ask is, at least on the surface, it looks like the constraint about being nonpartisan would constrain corporate or unit spending more than in the ad realm. And I just wondered what you all think.
I'm happy to take a crack at that. There isn't, as we all know, all that much corporate spending for get out the vote or voter registration. I take it that you'd like to see more of it encouraged and that this might be a source of funding, or are you concerned that it's going to become partisan?
This is actually a question. What do you think is going to be the impact?
I don't think it's going to be very significant because I think it's the consequences of voter registration as pertains to the outcomes of policy debates is so attenuated that I think it's unlikely that many people are going to see it as a reason to spend money in order to achieve an outcome, which is sort of what Citizens United would suggest is now permissible. I think there will still be some companies that do it as sort of a good citizenship thing, but I don't think that it's likely to become a tool of political advocacy for companies very, very much.
I actually have a slightly different view, which is that there's been a tremendous growth in voter registration and get-out-the-vote activities in the business community. I think that's been primarily because several groups, like the Chamber of Commerce and the Business Industry Political Action Committee, BIPAC, have encouraged business companies to increase awareness among their employees and stockholders and retirees about issues, about what candidates are running for which positions, and to register and to go out and vote. We have early voting, which is a relatively recent phenomenon, so people can get absentee ballots and vote early. And all of that activity was legal under previous legal regimes of the Federal Election Commission, and the Internet has made that extremely cost-effective. So I think there's been a lot of growth in that. I think it will continue, but it's not because of the Citizens United case. I just think it's something that has started about a dozen years ago.
Yeah, I think that what Citizens United does in that realm, especially voter registration realm, well, both really, voter registration, GOTV, it certainly frees up the kinds of messaging that can be done in connection with that. But voter registration in particular is pretty heavily regulated in the states in order to protect the integrity of that system and to hopefully assist people to register it. I don't think those laws are undermined and shouldn't be undermined by Citizens United. And I think we've talked a little bit about legislation, one area we should always be pushing for, I think, is better laws about voter registration to facilitate that, enable people to register more easily closer to elections, monitoring so it's done correctly and accurately. I don't see those laws or attempts at all as undermined by Citizens United.
Well, let's all thank the panel for a truly excellent and stimulating discussion. And
Thanks to ACS for sponsoring this event, and most of all, thanks to all of you for coming out and sharing your lunch with us. Thank you so much.